Good morning, everyone. Thank you for joining us today. We're excited to be kicking off the BioBreak BYOC, Bring Your Own Coffee panel. It's a bi-weekly interactive webinar series providing what we hope is engaging panel discussions on the most relevant topics in the life science industry. So we're going to be recording this session today, and it will be available for the attendees afterwards. I just want to note a disclaimer that we have a really interesting and diverse panel here today, and the discussion and the opinions that you're going to hear are those of the individuals themselves and not of their law firms or companies. And everything that's being discussed is considered off the record. So I first want to thank our sponsors today, the advisory and accounting firm of Witham and the global life science transaction firm Locust Law. With that, I would like to get right into the introductions to our panel. We have 4 panelists, and then I will be moderating. I'm going to turn it over. I see Martha on my screen. So I'm going to turn it over to Martha first to introduce herself.
Good morning, Martina. Thank you, and welcome everybody to the BioBreak panel. I'm a big fan of the meetings we have in person with BioBreak, so I'm looking forward to when we can get back together as a group. I am currently the general counsel of Marinus Pharmaceuticals. It is a rare disease clinical stage CNS company, and I've been working in the biotech sector basically my whole career, although I started out at Morgan, Lewis & Bach as a business and finance lawyer, and then spent 5 years as general counsel to the Wistar Institute. After that, I've been in the biotech business my whole life. Since I'm a business and finance lawyer, not an IP lawyer, my perspectives today will be from that vantage point.
All right, Guy, do you want to go next?
Thank you, Martina. So my name is Guy Donatello. I'm a patent attorney. I've been involved in the pharmaceutical and biotech industry for my whole career, which is about 33 years now. Worked for a couple of law firms where I was a partner, and the Roman Haas Company, and then I've been chief patent counsel for Endo Pharmaceuticals for almost 18 years now.
All right, Mary?
Good morning, everyone. My name's Mary Bach. I'm a partner at the law firm of Howson & Howson. I, too, am a biotech pharmaceutical patent attorney, mostly doing prosecution and advice work. And I'm not going to give you the number of years I practice because that just is too much information. But I have been with outside counsel with private law firms for most of my career, except for a brief stint at Genetics Institute many, many years ago. I'm looking forward to this discussion.
All right, and last but not least on our panel here is Daniel.
Hi, Dan Scolnick. I'm a partner at, we're now called Troutman, Pepper, Hamilton, Sanders. I was formerly of Pepper, Hamilton. I've been doing this for 20 years or so, and I do biotech and pharmaceutical patent work and transactions and advice, similar to Mary. And Martina, you still have to introduce yourself as well, so not quite last.
I was strategic. I said last on the panel. So,
there you go.
I am Martina Hufnal. I work at Richardson. I've been practicing for about 15 years. The last 10 of those fairly exclusively in the life sciences and chemical arts. So I'm a litigator. I bring a bit of a different perspective than the rest of the group, which is probably why I was tasked with being the moderator and not giving opinions. But I will chime in here when it's appropriate, and I have something that I think is useful from a litigation standpoint to talk about. So we're going to cover today, I guess, thank you all for participating in this panel, and thank you all for joining us. So we're going to talk today about really a wide range of topics on intellectual property, starting with how it can be protected, your intellectual property, how it can be protected, and then kind of ending with and how it can provide value to you, your clients, your business. Most of our discussion, I suspect, is going to focus on patents. However, trademark or trade secrets are an important part of your intellectual property portfolio. And we are at times going to be talking about the intersection of patents and trade secrets, the benefits of one versus the other, and potentially some of the drawbacks. So Mary, I'm going to start with you. If you could perhaps take a moment to explain, what is a patent, what isn't a patent, and what can you do, what can you not do just because you have a patent. And when you talk to your clients, what do you see your patents? Why do they want patents?
Okay, well, that's a big subject. So just to start off at the elementary level, a patent's a legal document that describes sort of the metes and bounds of an invention. And things that can be an invention can be compositions of matter, methods, apparatus, software, all different kinds of things that fall into methods and compositions. And your patent on whatever one of these is, whatever your invention of choice is, obviously your invention, to get a patent claim, it has to be new, it has to be useful, and it has to be non-obvious, which is always the issue that becomes the question. But once you get a patent and you have patent claims, that the claims are the part that legally cover your invention and what you can do with it. A patent lets you prohibit someone else from practicing that invention, and that means making, using, or selling that invention. What a patent doesn't do is, surprisingly to most people, is let you, the inventor, practice it if any part of your patent claim covers somebody else's invention. For instance, say a method of treatment claim or a method of diagnosing claim. If you use a reagent that someone else has a patent on, then while you can stop others from practicing your method, the person who has the patent on the key reagent that you need to practice your method can stop you unless you two get together and collaborate on how you're going to handle the legal rights. So normally what my clients do with a patent is they use it if they are institutions, nonprofit institutions. They may use it to interest people with money in supporting the labs. So they may license it or license part of it or different fields of use to raise money. You can use it to, you can sell it because it's a piece of property. You can, actually some people use it to create prior art to actually make sure that their patent application discloses information that they may not want other people to be able to patent, so that if you put it in your patent application as of the publication, it becomes prior art to prevent other people from patenting. So there's a lot of different things you can do with the patent once it grants.
Yeah, I guess, Daniel, from the outside counsel perspective, anything to add to that, and then I'll turn to Martha and Guy and see if they have anything from in-house.
No, I mean, Mary covered it very well. We always do have to emphasize with clients about the issue between what a patent does let you do and what it doesn't let you do. I actually have had this conversation yesterday with someone who wanted to patent a combination of certain components for a formulation. And one of them is covered by a patent, and then we got into this very long discussion about what that means, and so that's a very important part of it. And I know later we're going to talk about sort of looking at the landscape and how we do that, and I think that'll tie into sort of how we focus on patents as well.
So Mary said something. She said that that it's surprising to many people that a patent doesn't allow you to practice an invention. And it is surprising. I find that with a lot of clients, they're surprised by that. But if you think about it intuitively, you'd realize that's the case. So if I found a new method of treating COVID-19 with remdesivir, well, everybody knows that remdesivir is patented, Gilead owns it. So just because I now figured out how to treat COVID-19 with it doesn't mean I can run out and make it so that I could use it for that, because their patent on that would stop me. That makes sense intuitively to people. Conceptually, that applies to other things. I just want to point out, someone on the chat pointed out that patents are issued country by patent that you get in the United States only covers the United States. It's not enforceable in Canada or anywhere else around the world. And we'll get to that a little later, but if you want a patent that's enforceable in Canada, you need to apply for a patent there, and then country by country around the rest of the world.
Okay, thank you. So Martha, let's get you up here on the screen. When you're talking to your business unit, you work at in-house and you have to tell your business, I need a certain budget for filing patents, and it's not an insignificant, depending on the size of your company, I think the filing fees for patents are about $3,000 alone, and then actually prosecuting the patent can run, $10,000 to $20,000, at least in my experience. It depends on the importance of the case and whether you're using outside counsel and all that. But so you need to convince your business that you need a certain budget for getting these patents. What do you tell them? Hey, this is why we need patents, even though it's not going to guarantee we can practice what we're inventing.
That's a great question, Martina, because it is an issue. Clearly, I've worked mostly with small biotechs, although I have worked with some larger ones, and the budget is always a key issue. So you really need to make your business partners understand the value of patents. And in biotech, it's really the underpinning of the value of the business. So I tell my folks, listen, it takes years to get through the preclinical testing and the clinical testing to get an FDA approval. And when you get on the market, what guarantees you your exclusivity on the market so that you can recover your investment and have funds for other investments is really that patent protection. You do also have regulatory protections under the Food, Drug, Cosmetic Act. I think we're sticking mostly with US law today, but that's a short period of time compared to what you can gain from patents. And so your ability to be on the market and protect your market is really critical. So it's really easy for the commercial guys to understand that, because they're always doing, what's the value of the product? What are my projections? How long can I go out with my projections? And that is really all a factor of, how strong your patent protection is and how long you can maintain that exclusivity before the generics or the biosimilars are coming in.
So Guy, I'm going to put back to you for a moment to stick with this concept of budgets and convincing your business that you need to spend some money getting some patent applications. Can you walk us through, at a high level, some of your best practices when somebody comes to you from your company and says, hey, look, I have this new idea for a product, or hey, we just tweaked our process and I think this could be a good idea for a patent. What are the kinds of things that you think about? Hey, should I get a patent? Should I not get a patent? Do you consider trade secrets? When might trade secrets come in? And one of the questions that we got before we started today was, can a patent still protect confidential information? So is that something that you take into consideration when you decide whether to file patents?
Well, first, I want to say, you go, Martha, because that was a great explanation about why it's so valuable. And we have that discussion all the time. When you look at the amount of money you're going to put into marketing, the amount of money you're going to put into research and development, the cost of a patent, especially in just the United States, is really rather minimal compared to everything else that you're putting into this product, into developing it, into figuring it all out, because there's an awful lot of that. And I tell people, nobody would build a house on land they don't own. And that's what you're doing. If you do all this research and you don't protect it, then basically you're just giving it away, and nobody can afford to do that. So we generally err on the side of filing patent applications. Now, the one thing is, there are a few things that you have trouble getting patents on, and you have trouble enforcing in patents. So getting patents, Mary was right, almost anything under the sun is patentable, but recently there's been a trend towards unpatentability of, and it's always been that a product of nature or natural law is unpatentable. They've been expanding that recently and making some more things unpatentable, and we've been fighting that to some extent and had a case about that not too long ago. So in those cases, we tend not to file if we don't think that we'll be able to meet the standards for getting a patent. But in most other cases, we go ahead and file, especially if it relates to a product that we have on the market or we plan to bring to market, right? As far as trade secrets, so one of the deal with a patent, and the reason that the government grants patents, is that they want everybody else be able to, they call it stand on the shoulders of giants, to see what scientists have done, see what work's been done, and to be able to build on it. So the deal is you have to disclose information in order to get your patent. So trying to keep information confidential when you're getting a patent, the two don't really go together very well. So it's hard to keep information confidential if you're going to go and get a patent. You really have to choose one or the other. Now, trade secrets in the pharmaceutical industry, so much is disclosed to the FDA, so much is disclosed when you get your product approved, that it's hard to keep significant portions of that trade secret. However, trade secrets apply in pharmaceuticals to a large extent in the methods of manufacture. So sometimes people think it's easy to make drugs. I can tell you that it's not. It's incredibly complicated. Now, I can bake chocolate chip cookies, but if I want to make sure that every chocolate chip cookie is within 1/10 of a gram of every other chocolate chip cookie, and every one has exactly the same number of chocolate chips, that's not so easy to do. And all of the methods that go into that, now, generally those don't get patented, and those patents would be very difficult to enforce because you wouldn't know whether a competitor was using your process. So usually it's not worthwhile to patent that kind of information because it's very specific to the machinery you use and exactly how you do everything. We tend not to patent that information. Instead, it's maintained as trade secret. Part of that is maintaining access to it to only the people who need to know it and keeping other people away from it and making sure that people know that it's a trade secret. So trade secrets does have a place where patents don't apply and aren't so easy to enforce.
Daniel or Mary, do you have anything to add on to this topic?
No, I mean, I think what Guy said summed it up very well. We do have so I work with a lot of startups and that sometimes come out of universities or just more nascent technologies, and we do run into issues. I used to have a lot more diagnostic clients, but that is, as Guy said, the courts have sort of put the kibosh on, I would say, valuable diagnostic patents. That might be changing a little bit slowly but surely, but it's going to take a long time or a fix by Congress to fix that. So on the biotech side, outside of manufacturing, a lot more of that part of it is being kept as a trade secret, or if and that leads to the sort of the algorithms or the math that's behind the diagnostics keeping those secret.
I would say, Martina, from the inside, it's critical to keep it a secret. And a lot of times your business partners want to share it with more people. And you really have to make sure that you keep it very tight and you keep it under strict contractual requirements. Because the courts, if you don't, then they won't uphold that trade secret. So, sorry, Mary, go ahead.
Oh, no, I was just going to say that I had a client years ago that made mixtures of chemicals for industrial purposes, and they used to like to keep a lot of trade secrets, but as the governmental regulations require disclosure of components, toxic components, things of that nature, it does become harder to keep trade secrets in certain fields because of requirements to disclose.
Okay, so we have a few questions that are popping up on the chat that I welcome the panelists if anybody wants to kind of respond to any of those individually. Otherwise, I would say to those asking the chats, I believe we can help after this. If we don't get to any of your questions, we can, somebody on the panel could reach out to you and follow up with you specifically. One thing that I did get a question about, and we're going to cover because it is critically important is timing. So you file a patent, and there's different things that you can do. You could file a patent application, a brand new patent application. You could potentially try to file a continuation or a divisional. Different strategic avenues that you can take when you're continuing your line of invention. And if somebody who's speaking here wants to talk about some of the pros and cons of those different types, I welcome you to do that. But my question really is on timing, especially in the pharmaceutical area. Why is timing so critical? And do you have any recommendations on, during the drug development process, when should a company or a client really start thinking about, okay, now's the time to start getting some patents on file? Okay,
I can start. So I think a lot of it will depend on the technology in the area and the competition in that area for that space. I think in some instances you can wait till you have some data that you'll have fairly quickly, and in the chance of you being scooped by someone else is relatively low, and you can sort of put off that patent filing decision a little bit longer. In some competitive areas, and I'm based out in the Philadelphia area, there's a lot going on in Philadelphia in the cell therapy area, gene therapy area. There's a very competitive landscape at this point, and there are a lot of people working in this area. And so if you wait, there's a much higher chance of getting sort of beaten to the line. And in the US, which it's been a number of years at this point, is now a first to file system as opposed to it used to be first to invent, which is now aligned with the rest of the world. If you're not first to the patent office, you don't get the invention. And so there, although it's good to have data before you file, you don't necessarily need it, because you can design constructs, you can design what you think your cell line is going to look like, your gene therapy construct, and file on that as a provisional application. And then during the 12 months that you have between filing a provisional and a non-provisional application, you can produce that data. And sometimes a month or a week will make a big difference in this area. And that's also important for investors. I know, which can have an impact on timing. Patents, yes, are a legal tool in the sense of you can prevent others from being on the market, and you're protecting your invention. They're also a business tool in that if you're trying to raise money, sometimes you need a patent, or at least a patent application on file, for investors to see what your invention is and to understand where you're going. And so timing is critically important. People, I'd say, used to wait a little bit longer. I think people are now filing earlier and earlier. On the small molecule side, you can sometimes wait a little bit longer because the chances of people coming up with the exact same molecule are a little bit lower. But people, as soon as they have that data, that proof of concept in whatever assay they're using, usually file right away. And then obviously you don't have to worry about disclosures or inadvertent disclosures, because if the invention is made public in some way, that can really negatively impact your rights, especially outside the US.
Right. I would also add to what Dan was saying, that publication or prior publication is a big issue now. Even though in the US you still have a year from the inventor's first disclosure, there are so many ways that can trip you up. And if you're in if you're an educational institution or an institution that does a lot of publishing, that's a big problem. You really want to get your application in before you've published. And these days people put things on websites, and they may not even realize that they're disclosing what they're disclosing, but they put a lot on websites, on like small company websites or academic institution websites. You need to be really careful about that. So filing early is I think, extremely important. And I think we were going to talk about the on sale bar issue, which has come up since the Howson decision, the Supreme Court decision in 2019. And I'll just say about that file early before you start describing your product to someone that you want to give you money. Or more specifically, we try to tell people be really careful that you don't use any terms relating to sale, but offers for sales can trigger the on sale bar now. You just have to be very, very careful and file as early as possible.
So Mary's absolutely right. Of course, I do want to answer. There's a few questions that have come up that we can answer, I think, quickly and get some of these, get some of the answers people are looking for. So prior art it can come from anywhere in the world. So it's not necessary that it only come from the country in which you're seeking that. And poster sessions at university research days are almost always public disclosure. So that right there is going to be a problem for filing a patent application for you. You have to file within a year, but you still, generally, you want to file before you make any kind of disclosure. And there is a method for filing a provisional patent application that gets you your date, and then you file a non-provisional within a year. You get that early date. In most cases, in the pharmaceutical biotech setting, because, as Martha explained, it takes so long to get your product approved that getting protection quickly is not as important as getting protection that lasts as long as possible. And so almost always the provisional patent application is used so that the patent will expire later rather than sooner, a year later. The other thing I want to let people know to look out for is if you're in clinical trials, when you file your clinical trial protocol, it gets published on clinicaltrials.gov. That's a publication that can give you a problem with filing a patent application later on. So you want to make sure that you look at that and make sure that whatever you put in there is either not going to prevent you from getting a patent that you're seeking, or that you file a patent application before that gets published. So that one kind of trips people up sometimes. So make sure that if you're in clinical trials, that you review what's going to go up on clinicaltrials.gov before you send it in.
And I would add to what Guy is saying, your press releases sometimes can be your worst enemy. So when you're in-house counsel, you really have to make sure there's a robust process for reviewing everything before it goes out, looking at all the public disclosures and making sure you're looking at them, not just from, are they compliant, are they this, are they that, but from a pure IP perspective.
Okay, I also see someone asked for clarification on the on-sale commentary, so I'll try to get a little more specific about that. So it always was true that if you put your invention on sale before you file, you can create a bar to patentability. When the American Invents Act went into effect, the language of the on-sale bar, or the language of 102, the novelty issue, was changed a little bit. And then the Supreme Court in 2019 in the Howson case basically came down and said, we're not really changing the law. It's still true that if you use something, if you commercially exploit your invention before you've filed a patent, you can lose your right to file a patent. The issue in Howson, though, was related to when a secret sale, when a sale under confidentiality is sufficient to trigger that on sale bar. And it, according to the Supreme Court, it is if there are, if it becomes public. There's a lot that they didn't address. So the on-sale issue, you need to be really specific about what it is and the language that you're using when you're trying to commercially exploit an invention that hasn't been patented. Your best advice is to file before you start disclosing it to everyone, because each one of these on sale cases that have come down before Howson and even the few after Howson, they're very fact specific. So you want to make sure that in no way does it appear that you are selling an invention that has not been, for which a patent has not been filed. I hope that helps a little bit.
All right, so, and I'm not sure if there's one kind of specific question about in the span of clinical studies, when does it become important to start getting your patents on file? And maybe somebody spoke to this, but I just wanted to add, you do also have to be careful with the actual clinical study enrollment and what's disclosed in there, and if there's confidentiality obligations associated with the people who are involved, the investigators who are involved in the clinical studies, the participants. So from a litigation standpoint, these materials that you've heard the panelists talk about, abstracts given, CEO statements, verbal statements given and transcribed, press releases, this is exactly the kind of dirt that we litigators love to dig up to find, to try to invalidate a patent once you get into litigation. So, you know, sometimes it's inevitable that comments are made, statements are made before your patent gets on file. And you know, there can be arguments to get around that. What exactly was said, what exactly was disclosed, it doesn't necessarily mean you don't file your patent application, but you certainly need to do your diligence, because these things will come up in litigation down the road if you are enforcing these patents, which of course you're going to want to do if somebody is using this technology that you spent millions of dollars developing in the R&D space. Okay, so unless anybody else on the panel wants to speak more to timing, I'm going to flip over a little bit to location, which we have talked about, and pause. Anybody want to say more on timing right now?
I don't think so. I think we're okay on that one.
All right, so location. As somebody mentioned earlier, your patent is only going to be enforceable in the jurisdiction where you obtained it. So in the United States, you have to have a US patent to be able to protect your property rights in the United States. How, from your all perspective, and maybe I'll start with Dan on this one, how do you decide where to file a patent? What kind of questions do you ask your client in making that decision? And then Martha and Guy, I'm sure your business is going to be saying to you, yeah, we're selling worldwide, get a patent everywhere. Is that practical? Is that always feasible? And if not, you know, what are some of the factors you take into consideration in deciding where you are going to file? So Daniel, why don't you start off?
Sure. So the first question is always, you know, what is the product or service that you'll be selling? Since we do a lot of, mainly what I do is pharmaceuticals and biologics, it's usually fairly widespread worldwide. Now, this is where money really comes into play, because this is where the expenses, especially for small companies or those with more limited funds, really have to make decisions, and sometimes very hard decisions. Sort of on the default list, obviously the US, Europe, and Japan, but that can immediately cost you $20,000 to $25,000 because you have to translate the application into Japanese. And then it's sort of like, and then the question becomes to, well, how much more money do you have? And you start basically adding the major economic countries like China. South Korea is now a big country that has sort of come, I think, more prevalent in the last, I would say, 5 to 7 years. And then you add countries like Canada, Australia, and others around the world. When you compare sort of big pharma to startups and mid-size, the strategy is quite different. Big pharma will file in all sorts of countries that a small startup never would, just because they don't have the resources to do it. But it does come down to what type of patent it is. I mean, there had been a question in the chat about sort of a research tool. That would be a much more limited filing strategy for most of my clients, because they're difficult to enforce. You don't know who's using it internally. And so for that sort of patent, you might just say, well, the United States or in one country or two or region that that you know someone may be using it in. So you want to have that ability to enforce it if you need it. But this is where budget often comes into play, and people have to sometimes make hard decisions. But on the flip side, if you don't file in certain foreign countries, it can certainly limit the sort of the economic value that you get on the back end if you're trying to partner or license down the road. So it's usually a long discussion, and eventually they'll write the check, but it's not a fun check to write for many clients.
I think Dan's right. You have to look at what the invention is. You have to look at the market for it in different places. Different countries have different standards for patentability. Different countries have different standards for subject matter that's patented, method of use versus method of treatment. You can't necessarily file and get a patent on a method of treating a human, things like that. So you have to look at where it might be patentable. But you also have to look at the market there. It's not always worth protecting, filing a patent application in a country where it's going to be expensive, but where you don't see a market for this product. So it'd be nice to be able to file worldwide, but as a practical matter, it's not always worthwhile. You have to look at it almost on a country-by-country basis. So generally what we do, and what I know some other people do, is we have groups of countries that we file. So if we think it's a basic patent, so if we discovered a new molecule, we would file that fairly broadly. If we discover something that's very specific to it, in terms of, I don't know what an example is, but if we see something that is not a basic patent, it's maybe not crucial to us, we would file it in a much smaller subset of countries. But it would be either A, B, C, or D. We'd file in all of those countries, whatever group that we group that invention into, so that we're fairly uniform and we don't have, and it's easier to keep track of. And that's the way we do it, in kind of baskets. And then you also have to look at enforceability in the different countries. And I realize that many large corporations file very broadly, as Dan said. And one reason is they have offices in those countries, and they expect to be able to sell this in those countries. We don't have something like that. We're a smaller company when you compare us to the really big guys. And so we don't have offices all over, and we're not as likely to file it all over the world. There is a method by which you can file it, the World Intellectual Property Office, or the PCT filing. It gives you a couple of years before you really have to incur the large expenses and decide where to go. So if you're looking at licensing this out or partnering with someone, you can file it through a PCT process, and that leaves open your options. But eventually, time does run out. So 2 to 3 years down the road, you're going to have to make those decisions. And they are hard decisions to make because it's expensive. And the places where it's harder to get translations tend to cost more for the filing. Because if you have to translate it into Swedish, that's going to be a much bigger expense than translating it into Spanish or Italian or French. So you really, that's part of what the cost of the filing is.
I would agree with Dan and Guy that it's really basically what's the value of the IP. If it's a basic composition of matter, you have to go broadly because you really need that protection. I think, if it's something that is more useful for the US market for some reason, then maybe you put it in the US. Or if it's really a defensive patent that you want to just get out there, the publication, then you don't go so broadly. And I would also add to that, one thing that we do regularly in the small company, I've been mostly in small companies, so budget is always a key issue, is really get the people around the table once or twice a year to look at the full portfolio and call things that are no longer really key and strategic for the company. Those are hard decisions to make. Nobody wants to drop a patent once it's filed. I mean, there's a big reluctance to do that. And so you really have to get the key players around the table and look at that hard and fast. We could spend that money in a clinical study, okay? We really don't maybe need that patent application in this particular area. And, I would say the US, the EU, and Japan are always critical for marketing. At least that's been my experience when you're dealing with trying to license out your technology or find a collaboration partner. You need at least the minimum of that on the key patents that you have.
I was just going to say I completely agree with Martha. That's the biggest issue that a lot of my clients have, is continuing to enforce a patent in a jurisdiction where you also pay annuities, and so that also kicks in and it impacts the decision about where to file and maintain.
Yeah, there's one question that's kind of popped up here that I want to pose to the panel. We've talked about looking at what the invention is, and I think a lot of you have hit on, you have to see if it's enforceable in the jurisdiction that you're considering filing in. Do you think at all about, okay, where am I going to be making this product, and therefore focus potentially some processing patents on that jurisdiction? Do you ever look at your competitors and where their manufacturing facilities are and say, maybe I should get some manufacturing in this country versus the use, which I have heard is what you all are saying is that it's a much broader, you take a broader approach. So does anybody have any comments on whether you're talking about processing patents versus a use patent specifically, what factors might go into where you file?
Well, to some extent, you have to look at what you plan on claiming in your patent. I can tell you that if you're looking at where people are making things, China and India rise to the top. There's a lot of things are being made in China and India, and somebody commented that it has historically been difficult to enforce patents in those countries. And I think that has historically been the case. It got better. China's got good laws, but the enforcement of them is not as uniform as we'd like it to be, but it's gotten better. And although I don't know right now with the current climate between the US and China whether that's still true. But depending on what you claim, so if you claim the molecule itself, you may be able to enforce that in this country, even though the molecule is being made somewhere else. So you have to look at what the enforceability is here, as well as what the enforceability is in another country, because you may be able to choose the grounds in which you fight.
Make, use, or sell. We litigators can get to you for any of those.
Sell is a big one. I mean, just because somebody makes it somewhere else doesn't mean they, again, look at remdesivir. You could make it anywhere, but you try to sell it here, Gilead's going to have something to say about that.
Right. Okay, so we have about 15 minutes left, and we've been talking a lot about, I don't want to be kind of the Debbie Downer and how patents are expensive, and you have to really make strategic decisions. But patents, as Martha started out this conversation, can be financially advantageous on many different levels for a company. And there's lots of different companies that I use that term loosely. Universities count. Universities get patents. Startup companies. Then you have smaller pharmaceutical companies. And then you have large pharma. How, and I don't know who I should start with. Maybe Daniel, I'll start with you since we haven't heard from you here in a few minutes. What is some of the value that, say a company wants to, a startup company wants to file a patent to get some intellectual property so they can start getting it. And they can start potentially partnering with a larger pharma company to get into clinical studies. What are some of the landmines in those communications that that you need to think about, or that the company needs to think about. And the same could, I think, be applied to medium-sized pharma, universities. What are some of the landmines that you need to think about in trying to get value out of their patents by way of investor partnerships?
So I think some of the landmines, it's someone I think sort of asked this question about freedom to operate and understanding the landscape that you're in. With the clients that I work with, as they sort of start to go in from that, here I have an invention, I filed a patent application, now I want to go talk to people about it and license it. The people that may be interested in your invention will do diligence on that invention and to understand how it fits into the landscape. And we always counsel clients that you should be doing this, we should be doing this diligence ahead of time, so we know sort of what those hard and tricky questions are going to be, so there are no surprises. And so that means sort of doing a freedom to operate search. It doesn't have to be, you know, the most comprehensive FTO search in the world, but to make sure that there's no one else that could prevent you from using your invention. And then also looking at the landscape to understand where it fits in with your potential competitors. So when you have those conversations, you can really emphasize that, you know, not only do I have a patent application, but here's why it's valuable, because this is how it fits into the big puzzle. When people don't sort of take that time and effort to do their own sort of self due diligence, they can run into problems, because when you start talking to people, to partners or potential investors where you're trying to sort of monetize your intellectual property at that point, and you don't have good answers, it just slows things down. And they start to question sort of the value of it, and it brings up red flags. So we always talk about with clients sort of how to avoid those landmines, and that also involves, you know, having a sound prosecution strategy, making sure you're dealing with the patent offices in the right way, and making sure you're saying the right things or not saying the wrong things to the patent offices. And so you sort of take this global or comprehensive view of the world and sort of tell that story and make sure that you're aware of any landmines if they are, and you go around them so you don't have to hit them.
I couldn't agree more with Daniel, because it goes to your credibility. You're trying to, you know, get a partner interested in that you're the expert. You have this great invention. And if they bring up something that, you know, was out there and you haven't dealt with it, understood it, put it in a context, your credibility is really questioned. And I also think that as a practical tip, when you're, you know, looking for a partner or for a collaboration, we typically don't share our IP, our confidential strategy, until the very end, until you're really sure this is real. This isn't somebody fishing, looking to get information, because more of that is out there than you think. And we also oftentimes just do outside counsel to outside counsel, because that's another way to protect it without making sure that, you know, without having the inside folks see the more sensitive information. But I think it's really important you do see fishing expeditions, and I always try to make sure that my business folks will wait till, you know, we're pretty sure that this is real, it's within the framework of something that could happen, before we share our sensitive IP. You know, not some of the basic, obviously the issued patents, but the more sensitive and the strategy and our view of the competitive landscape and FTO.
And so what you were talking about there, Martha, sharing that type of information can not only create you know, public disclosure for our issues, it can create effect issues, right?
Yes.
And
they can apply it to their own. It's hard to unlearn the information that you learned. You can sign whatever confidentiality agreements you want, but you know, you've had access to some information, and there is case law on, you know, even reputable companies where there have been situations that, you know, things that have been shared under CDA end up in later inventions. So I just think it's a landmine. When you asked about landmines, it's one that I think you need to be careful of. you know, not really, you want to sell, you want a partner. So you're out there, you know, trying to make the best of your invention and giving as much information as possible. So that's why I see my role as sort of, let's back up a little bit. Let's share the right information, not the sensitive information, until we're, you know, in the framework where we think it could be a real deal.
Yeah, to those points, that's a place that I know when you start talking about diligence and partnerships, that's the role that I've played for clients much in the past, is talking to the outside counsel of a potential partner to talk about the freedom to operate, the diligence issues that we've done to make sure we can sell the product. And it is, you have to know how to approach those conversations, giving as much information as you can to show that we're on top of this, and yes, partner with us, we're going to be able to sell a good product without waiving any type of privilege issues or confidentiality.
Very true. I was also going to say one landmine is publishing in any way information that has maybe been developed subsequent to the filing of the application. A lot of times the inventors or people, when they're trying to get outside interest, may give a little more information than, so I as their patent counsel would want them to, because it may be hot off the presses information related to the invention, which isn't in the application because the application was, say, filed a month or 2 or 3 ago. And that it's important to always be careful about that too, about don't give out like the latest and greatest information if it's not in your patent application.
So let me pose maybe a slightly different question. You have a client who has this patent portfolio and they followed all of your good advice to file early, and maybe their product isn't working out. So now they have these patents that they're not going to get value out of in the traditional sense in that they're going to sell a product. What are some of the other potential avenues of obtaining value from patents other than just selling a product that's covered by that patent, if there are any? So Daniel's already mentioned licensing. Obviously,
yeah, I mean, you can try to license. I mean, there are firms and services out there that will try to monetize the patent for you as sort of a patent broker. I have not done much of that at all. You see a little bit more of that, I would say, in the software or electronic space than you do in the biotech space. But you can certainly try to license it. You know, if it's no longer a core asset for a company, sometimes it will be interesting to someone else and can be sold off. And you may not get a lot of money up front, but you can get royalties if it becomes successful for someone else. So yeah, I mean, there are definitely many different business opportunities, and depending on the size of the company or where the project is, the value can be, you know, very little, or in the long run be a lot more. It's one of those very fact-specific questions that it's hard to give sort of this is what you can do, but there are different ways to sort of turn a patent that you don't have any use for at that point into some value, although it's usually a lot more limited, I would say, in the biotech space than maybe in some other areas.
Well, how about universities? I mean, if we make it a little more tangible, and you know, universities don't typically sell products, how are they?
Yeah, I mean, universities certainly license it out. I mean, they have a lot of universities have very robust tech transfer offices that try to partner and license out their technology. Yes, so the universities are certainly a different exception. I don't do a lot of university work, so I don't get involved on that side as much. I'm usually the one evaluating the university technology after it's been identified. I don't know. I know Mary, I think, does a little bit more of that work than I do.
Yeah, I do think a lot of that depends on the tech transfer department, because there are ways. I'm always amazed that they manage to come up with different partners and sort of explore maybe a different way of using, you know, patent application X. It might interest somebody else who's doing a little bit different focused idea, but I think for the most part, for universities, that's what they're looking for anyway, is how can I monetize this? Is there a way to, is there anybody who would be interested even in doing a research deal that involves the patent application?
All right. Well, if no one has more comments than that, we have exactly 4 minutes remaining. So I thought I would let all 4 of you panelists, you each get 1 minute if I don't waste too much time here, to just give a takeaway. What advice would you give? You have lots of folks on the listening in here. If they're trying to manage a patent portfolio and they're feeling a little overwhelmed by their own, whether it's for their clients, whether they are in-house or not, other than, I guess, hire a lawyer. Maybe I shouldn't say other, but that may be someone's advice. But have a piece of advice that you can convey. So Martha, go ahead.
So my one piece of advice is get buy-in, get an IP committee together, make sure the highest commercial and research people are on it, and really make those decisions together. Get buy-in so that you're not standing out there alone trying to support your budget. You want their ownership in that. And so I've used that as a tool in all of my smaller companies.
I agree 100%. You really have to get buy-in from the commercial and the research folks, and they can tell you what the research folks can tell you what they think they can do, what the patent can cover, whatever. The commercial folks can try to value that. It's very important. Someone had the question, what's the best way to value IP? I think that's very funny. We get that sometimes. I just want to say it's intellectual property. You have to think of it as a lot of parallels to real property. How do you value real property? I don't know, is it 40,000 acres in Alaska, or is it 1 square block in Manhattan? How do you value it? It's easier there because it's easier to find comps, but it's the same thing. You have to hire, to some extent, hire an expert, do your research. It's difficult to do.
My brief idea would be know what's in your application and have some group, like Martha said, of the inventors maybe review it periodically, because a lot of times people think they know what's in their application from memory, and their memory can be faulty.
So true, Mary.
And my one little piece of advice is especially when I'm talking to potentially new clients, I always talk to people about what's the purpose of the patent application that you want to file or that patent you have. As Guy said, it's equivalent to real property in many senses, and it needs to have how is it helping your business, and what do you expect to get out of it? And that question is often not easily answerable, and if you can't answer it easily, then it can sort of raise the question of whether that patent is an actual value for you. So that's my one question I always ask clients is, why do you want to file this, and make sure they have a good answer.
All right. Thank you all. I really want to thank all the panelists, Martha, Guy, Mary, and Daniel. I feel like this has been an interesting conversation. And thank you for everybody dialing in, the attendees. Thank you to our sponsors, Locust Block and Whipham. So just a reminder, this was recorded, and the recording will be sent to the attendees, to the emails of each of the participants shortly. So next, we have Wednesday, September 2nd at 9:30. Our Bring Your Own Coffee panel will be on Human Resources Diversity 101. And we look forward to seeing you all in person soon. And in the interim, stay safe, social distance, and continue to do the great work that our industry does. Thank you all very much.
Thank you. Goodbye.
Thanks, everyone.